These Creditors in Commerce workshop sessions, hereinafter sessions, are the private exchange of ideas and concepts between the providers and the recipients. The content is not meant as legal advice. The use or attempted use of any idea or procedure discussed in these sessions, as applied to the recipient's own personal transactions, cases, or controversies, or applied to other cases, may or may not result in a favorable outcome or the same outcome as discussed in these sessions. Each transition or transaction, case, or controversy may be different as a result of unique actions or unique statements made by the parties therein, and each different act or statement in any transaction affects or may affect whether any procedure or idea discussed in these sessions is relevant to the recipient's transactions or that the outcome thereof will be depicted as in these sessions. The discussion of ideas or procedures in these sessions is not exhaustive of the subjects being discussed. Many ideas and concepts that can affect the outcome of any legal or commercial procedure are not discussed in these sessions, and the fact that recipients may not be aware of these issues may have an adverse effect on the outcome of the recipient's procedures. It is the responsibility of the recipients to understand their own transactions and to apply the appropriate and complete concepts necessary for a procedural and substantive remedy thereto. These sessions may be redistributed privately by any recipient to another recipient requesting them, condition upon the fact that this notice is provided therewith. If you have any questions, you may contact Creditors in Commerce by email at harmony@creditorsincommerce.com.
Real quick, what I'm going to do is go through the process of how we would treat account settlement in the court or on a court case. Now, we talked yesterday about account settlement and we went into details. I'm going to spell out the process in a little more detail right now. So, court account settlement, step one, and I'm also going to call this record number one. Okay? First, we want to A for B, the complaint or indictment. Okay? We're going to include with that a money order. Now, let me show you a sample money order, one you can create that because typically a complaint or indictment may not have one. An indictment actually won't have an amount.
We won't even know, so you're just going to give us an amount.
But a complaint for money would have an amount. So a complaint for money, we would just put the total amount of the complaint. Okay? So let's get this to come up.
Is that going to be on the download?
This will be on the download.
Brandon?
Yes.
And you say you A for B each page of the indictment?
Each page of the complaint or indictment, front and back. Okay? Now, I prefer the A for B language that is settling it to 0. That's just me. Because if the amount includes penalties, fees, and if it's an indictment, or there's no sum certain clear on the complaint or indictment, then you really want to use the language of just settle the account to 0, because we don't know what the sum certain is. Okay? So we're going to do every page. This is a sample, this is a money order I created, and it's very simple. It's got a date, a tracking number, because I'm going to send this register mail. That would be the register mail number. It's like an instrument number. Pay to the order of, this particular one is Franchise Tax Board. Pay, and I write out the amount in words. Notice how it says dollars over there at the end, and then up above that you have 4 and the numbers written out in digits. Down below that you have a memo line which has the account number that this is being attributed to. If this were a court case, what would I put there? The case number. Okay? By authorized representative would be the signature. Down there in the box would be what? the straw man or public trust name and address, and then you see below there, there's another account number. That I would put as the social, no dashes.
The account number is social, no dash.
The one below the straw man information. So I have up in the memo field the account number that it's to be attributed to, and then down in the account number field I have the social, no dashes. And then you see over here I have the processor, IRS Technical Support Division, and that's where I'm probably going to be sending this first presentment. I don't have to send it there, but I'm preferring this new process because it's almost like having a second witness to the tender for set-off.
Not to the mail stop?
Yeah, I would send it to the mail stop. That is just the Department of Treasury address up there, but you could put either one. I could use that address and mail this entire thing to Ogden or Covington, wherever I'm sending my set-off to, but the actual IRS Technical Support Division is that address that's located on that processor part of the money order.
What if you use a mail stop or Ogden, you would put their name and address
No,
there?
I would keep this same. Me personally, I would just keep that the way it is and still send it to Ogden.
As far as the pay to order of and the amount, what if you're dealing with, like with me, traffic, and you don't know what the amount is?
Basically, you would leave the amount blank.
Okay.
Okay?
Okay.
Okay? Yeah, and I would use the A for V language that zeroes the account. Now, I would also include, because I'm sending this through the Technical Support Division, I would include a 1040V. All the taxpayer information would be on there. There would be nothing in the amount. Even if I did have a sum certain, I would not put an amount in the 1040V in case there's any extra fees, penalties, interest, or anything like that. I leave the amount on the 1040V blank, and I put the special endorsement on the back of the 1040V with a signature. I would also endorse the money order, but it would just be a signature, as if the money order is basically, we don't have a coupon, right? If we got a complaint, there's no payment coupon on a complaint. So the money order is taking the place of what I would usually do with the payment coupon, okay? I would include, remember yesterday we discussed the notice to set off accounts. There would be a certificate of service. Now, the certificate of service that's actually going with the presentment, would it have a signature? No. Learning. Okay. But in my record, would it have a signature? Yes. And it would be an original. Okay? And then 10 days later, I would get my certificate of non-response. All these documents together, we're calling record number 1. Okay? Even though this last document comes 10 days after presentment of all these other documents. Okay? Step number 2. And this is going to be referred to as record number 2. So step number 2, if I do step number 1 through IRS Technical Support Division, step number 2 is going to be presented to the attorney for the plaintiff, because that's who I'm contracting with. The notice of tender for set-off is basically giving notice that tender was submitted for the set-off of the obligation debt. Right here, this request regarding a statement of account, I forgot, and it should be inserted right here below the notice of tender for set-off. I'm also going to include in this presentment, step number 2, the complete record number 1. It's also going to have a certificate of service. The certificate of service included in this presentment would not have a signature. However, my record number 2, would have a certificate of service with a signature, and and then 10 days later, a certificate of non-response to this presentment. Make sense? Okay, so this is all of these documents together are record number 2.
The certificate of non-response on the first step that you're going to send to the IRS technical support. So basically, we're anticipating that at the end of 10
Am I sending the certificate of non-response to the IRS?
Okay, so what all is going to the IRS is that...
Everything above the line goes to the IRS.
Ah, okay, my bad.
Okay? A for V, complaint or indictment, the money order, the 1040V, the notice to set off accounts, certificate of service.
Unsigned.
Unsigned.
Okay.
That's what goes in the presentment. All of this together, including the certificate of non-response, is record number 1.
Okay.
Notice that in step number 2, I include record number 1. Does that include the certificate of non-response? Why would I include the certificate of non-response? To show that it was accepted by the IRS, Technical Support Division.
Okay.
Okay? Everyone clear on step number 2, record number 2? This is being sent to plaintiff's attorney. Now, who's the party that's named in the presentment as the recipient? The plaintiff. Now, I actually name anyone and everyone named on the document. So if there's 2 or 3 attorneys named on there, they all get notice too.
He wants to cover anybody that's involved in it. Communication with everybody involved. If you have a probation department involved when you're doing a set-off for supervised release or something, or a psychologist involved that you've been seeing, or a probation department, whatever, you need to send.
And why not send it to, let's say it was a complaint for money because of a bank debt. I would probably also send this presentment to the CFO of that bank in his private capacity. What am I doing by sending it to all these parties?
Getting their agreement.
I'm getting all of their agreement. All parties involved agreement, right? So, 10 days later, certificate of non-response on step number 2. Now, all of this together is record number 2. Maybe this isn't going to be as snappy as I thought. Go ahead.
But if you're dealing with the state official...
Speak up in the speaker.
If you're dealing with the state official and you send it to the CFO, and then you probably send it to the, the DA's office.
What do you mean a state official? Meaning it's an indictment or it's some kind of
about a
process.
ticket.
Right.
Let's just talk about, and he's asking about a ticket, so let's keep it.
Ticket? Wow. I wouldn't waste my time. My time's worth more than a ticket.
Okay.
But if you want to spend your time
right.
on this, yeah, I wouldn't do this on a
He's
ticket.
just
but
saying
if
choose
you want
your
to
battles,
do it, yeah,
don't do
choose
a
your
ticket.
battles.
Okay.
But if it's a $500 ticket and you're like, for me, this entire process would probably cost me $500.
Okay.
So, with all the notary activity and everything that's going on here, all the registered mail, everything else, like really, let's weigh the pros and cons here. Am I going to spend $500 to set off a $100 ticket?
Exclusive of his time. Because the notary has to be, you got to get a good notary to do this, and it's expensive.
Well, because the notary also acts as a document custodian.
They have to keep these records.
I understand. Okay.
So don't look for a notary that you pay $20 to and expect to get service, because you're not.
Right. If they're not experienced in commercial presentments, you may want to at least make sure that interview them. What are you going to do with the records I bring to you?
Or talk to Deborah in the back. She's in the back there, and get her to do it for you. And she can do it out of state, in state, whatever. If you can't get somebody. So if you need to, there's a qualified notary in the back here. Visit with her some before you all leave.
Okay, step number 3. Notice of fault, opportunity to cure. This comes 10 days after the first presentment. So really, this presentment is executed at the same time the certificate of non-response for step 1 is executed. Is it not? Okay.
Which is also the beginning of step 2.
Right. No. Yes, the beginning of step 2, you would execute the you would execute the certificate of non-response from step 1 at the same time you make presentment of step 2. Okay.
At the time you begin step 3.
No, step 3 comes 10 days later. So the time you're executing the non-response for step 2 would be when the presentment for step 3 happens. Notice that along with my notice of fault opportunity to cure, I'm including record number 2.
Which
and
contains
I make
record 1.
And I make reference to it in the notice of fault. Whenever you're enclosing documents with your presentment, this cover presentment page should make reference to that document. And it should be in the language such as, like in my notice of faults, I'm basically spelling out that on such and such a date, presentment of an indictment or complaint for money was issued
Statement
by...
of all the facts.
Yeah, statement of the facts issued by such and such a party, received by such and such a party on such and such a date. On this date, presentment of the payment was made, and on this date, presentment of the notice to set off accounts was made, right? And then, and I would make reference that pursuant to the record enclosed herewith and incorporated herein by this reference. So basically, I'm taking record number 2, and by using that language, record number 2 becomes part of my notice of fault.
Brandon, does record 2 that you're including in record 3 there in step 3, is that the record 2 that contains record 1?
Yes.
Yes, okay, just checking.
So because my statement of facts and my notice of fault is going to include everything I've done up until that date, right? And now record number 2 has everything that I've done up until that date, right? Okay. Along with that would be a certificate of service listing everything. 10 days later, certificate of non-response to my notice of fault. At the same time I execute this certificate of non-response for my step number 3, and all of these documents together, including the executed certificate of non-response, is record number 3. So record number 3, does it include everything I've done up until this point? Yep. Okay. So at the same time I execute that certificate of non-response, I'm going to execute my notice of default, step number 4. Along with my notice of default, I'm going to include record number 3. Record number 3 includes everything I've done up until this point. I'm going to make reference in my notice of default to record number 3, attached hereto or enclosed herewith and incorporated herein by this reference. Along with that goes a certificate of service. 10 days later, after the notice of default, I'm executing a certificate of non-response. Now, why? Am I even asking for a response in the notice of default? No. But why am I going to do a certificate of non-response on the notice of default? Why do I want a certificate of non-response to the default in my record? Right. It's an offer, right? Is my notice of default not an offer? So if I certify that they didn't respond to the final offer of default, they're agreed and accepted their default. Okay? So this comes 10 days later after this presentment. All of this together is record number 4.
You hold back up one real quick. Just want to make sure we stay on course. Step 1, we know that goes to the IRS tech support.
Right.
Step number 2, that goes to the attorney of
Right.
the plaintiff and the CFO.
Right.
Folks. Where does step number 3? That goes where?
You tell me. Where does step number 3 and 4 go?
Would they go back to the attorney?
Who's faulting?
Okay. Okay. So okay.
Okay? So
Right.
it's going back to the
attorney.
everything after step one goes to the attorney. We're done with the IRS after step one.
Right. Okay, I was just trying to get to what point that you send it to the judge, but okay.
We're almost there. We're almost there. We're getting there.
Okay.
Okay, so record number 4 is everything I've done. Is it not? So I've got a certificate of non-response, notice of default, notice of fault, step number 2, which was my notice of tender for set-off, and my request regarding a statement of account. Now, the request regarding a statement of account is really how we establish that this has been set off. When they don't respond to this request regarding a statement of account, we've established that by their agreement and the IRS's agreement, we've got a zero balance, account's been settled, everyone's golden. Right? All right. Here we go. Step number 5. Presentment of evidence under seal into judge's chambers on this case. And along with my presentment of evidence notice, which serves in substance to be a letter rogatory, I include record number 4. And that is everything. Record number 4 is everything I've done from step 1 through step 4.
With the originals.
And of course, I'm going to make reference to it in the presentment of evidence, enclosed herewith and incorporated herein by this reference. Right? So now that cover page that the judge is reading really includes the entire record. Right? Notice here in parentheses after record number 4, I have originals.
So we better say the non-responses, certificates of service,
all certificates
all
of
originals.
service and all certificates of non-response, I'm keeping the originals. I actually execute multiple originals on all those documents. So that in case the judge doesn't follow the instructions of presentment of evidence and I never get them back, I've still got a record of everything, of originals. Typically I do 3 or 4.
Although the original money order, that goes to the IRS, doesn't it?
Yes. The original
and the judge there'll only be a copy of a money order. We won't make original money orders.
And make sure any instruments that you ever include in records clearly have copy stamped over them. Why is that? Any negotiable instruments. Because it'd be counterfeiting if I did not use a copy stamp or something like that on the instrument. Okay. Now that's it. So, now that we've done this, and our presentment of evidence notice really is also going to give the judge direction or a call to action in regards to record number 4, which is everything that's happened, right? And because the judge, basically I'm saying, okay, we're all in agreement, account's been settled, this matter should be dismissed with prejudice, right? Because it's been settled on the private side. Now, do I have to show up to court? Nope. Let's say, now I'm going to watch the docket, okay? Make sure if you choose not to go to court, you watch the docket. What happens if it seems as if your process didn't work and you get a summary judgment filed in there? What would you do? Or a default judgment? It's an offer. And didn't Jack just give you an entire process regarding how to handle that? Conditional acceptances, making reference to record number 4. We have a microphone over here.
Okay, my question is, this is a long process that is all designed to cure the bank not really zeroing out your balance. Now, isn't
Whoa. What do you mean not really settle out the balance?
No, What I'm saying is that I think if the bank had actually gotten your funds from your treasury account, they would have dropped the foreclosure.
Really? You really believe that?
Well,
Remember, they're not getting funds. See, what you guys don't understand is when you send in A for Vs, nobody gets any funds. The IRS goes in and sets off the debt. Did HJR 192 say, yeah, we're going to pay money for your debts? No, we're going to set off your debts. That's why when people do A for Vs on their credit cards, they get shut down. Because the bank didn't get any money. The debt got set off. And they're like, well, why are we going to keep this account open? Because that money that usually comes in on your monthly payments goes to investors. Why keep this trust open if there's no money going to the investors? This guy's just going to run up his card every month and set it off.
Sure. Well, Jack was telling us then that he was saying you're always going to have an empty account, a liability account that doesn't get filled up if you don't.
Is there money, Jack?
Okay.
No, it's accounting.
So you're really just trying to enforce the bank that's foreclosing to clear up their accounting.
We're not forcing them.
No, you're trying to get them to do that. That's your remedy.
We may be coercing and manipulating, skillfully operating our process such to achieve balanced account. Now, the account is balanced, is it not? I mean, it's step number 2, they agreed that the account's balanced.
Well, tacitly.
Are you telling me that's less than an agreement?
Well, that's my question.
You believe in an express assent, yes, you got us, is any different than a tacit acquiescence that yes, you got us? It's yes or no?
Let me ask you this. IRS sends you notice of lien, notice of levy. You don't respond. Do you walk in and go, tacitly? And IRS goes, oh, tacitly, I guess that doesn't have as much weight. We won't levy you. No. They're still going to levy you.
What I'm saying is if the bank was satisfied, would they be continuing on with
They're
their
not
foreclosure?
satisfied because it got set off. They didn't get FRNs.
And
They're greedy.
And they only want FRNs.
They only want FRNs. They don't want the books balanced. They want money. What they call money. They want debt. Right?
Interest payments, etc.
I mean, let me ask you. If the IRS came in and says you have to set off his account, and you're like, well, I want Federal Reserve notes. We don't care. Set off his account. Are you happy? Not necessarily. She may be happy with that. Because in reality, is that not a tax credit? That's a debt cancellation. So the bank gets something out of it. Now, are they happy with the tax credit? Not as happy as they would be with Federal Reserve notes. But the fact is, they got valuable consideration. The set off of that account is a valuable consideration. It's just not as valuable to them as Federal Reserve notes.
I think what we're seeing here is the way eventually you're going to want to think of going is that if you're from the Republic, let's try to get up and operate from the Republic as much as possible. If you want to have a significant presence in the democracy, that's fine. And these things do set off the accounts across there. But, you know, we touched earlier on the fact that if you truly start operating out of the DTC, you're going to have a card, you're going to have instruments to do banking, in essence. There's going to be methodologies to go between the private and the public, which are going to look transparent to everyone. Is this process transparent? No, it's an administrative process that's got to be done on a transaction by transaction basis. It's perfectly great. And what we're learning to do right now, particularly until people understand how to get into the Republic in terms of operation, this does okay to get rid of some problems. But it's too intensive in terms of labor and cost to go out and buy your groceries this way or to pay a traffic ticket this way. But if you took a card from the DTC and swiped it and walked out with your groceries, and that's not what you're going to do with that card, but you could do it with that card, it's perfectly transparent and your life gets simple. We got to deal with this because our brain is stuck between two worlds, of which most of us are just learning about the second world. And we're neither ready, willing, or able probably to do the full transition.
Plus, we don't know how to do the full transition as of yet, but we will learn it.
Brandon? The success of this is based on non-response. Is there any concern that the CFO could respond in a way to cut it off?
No, because in fact they can never respond the way we ask them to respond. If they respond, how would you proceed? Well, is the CFO ever going to respond?
Go back to the 213th Articles and Amendment and answer the question.
Some other party is going to be interloping in the process. What you do is you use that party as your second witness. Let's say I'm at step number 3, notice of fault. And right after I send out my notice of fault, they're finally responding to step number 2. And I get it from some guy at the bank saying, oh, this is meaningless. Am I going to stop my process? Nope. This keeps going. The timeline on this keeps going. However, I'm going to address him. I'm going to conditionally accept his position. And I'm going to include an affidavit. And what else do you think I'm going to include? Record number 3. You could, but why not get a second witness? Right? I could say refuse for cause without dishonor, reason, frivolous, insufficient, deficient response. This isn't a response. We defined response.
But you don't want to dishonor that guy. Don't insult him. Don't do anything. We're happy, kind, helpful. The only problem is that third-party guy that came in is an interloper. Yep. And he's in the public. If you start discussing this case with him, you've just moved the situs of your remedy from private to public. What did that just do with all of your process? So you cannot deal with these guys, but you got to courteously respond. I conditionally accept everything you're saying on proof of claim that my private process over here with the CFO or whoever you're dealing with will not make anything that you're talking about here moot. Because when I'm done, we'll have it settled. Thank you very much. And then you send a copy of that conditional acceptance to the CFO or whoever you're dealing with so that he knows there's public officials interfering in your process.
When Jack uses the word moot, it's spelled M-O-O-T, and it's not mute, and it's defined as not worthy of consideration or discussion because it has already been resolved or no longer needs to be resolved.
Here's a metaphor I give. You're in a battle, and the target is the aircraft carrier. And you are dealing, the CFO is the aircraft carrier, he's the heart, and you're dealing and you're flying over with your plane to deliver the A for V, R for V, and all these records in process.
Your ordinance.
Don't you think they're going to send up some fighters to intercept you? And if you get drawn off in a battle with those airplanes that come up to intercept you, you're never going to close your deal with the CFO, the aircraft carrier.
Go ahead.
Like Georgia's a non-judicial state, so let's say that somebody's under threat here, and they get all the way down to the final step, but there's really no court action going on because the court doesn't get involved with foreclosing.
What's the title of this? What's it say at the top?
Court account settlement.
So if it's not a court account, is this relevant?
Okay. Well, okay, I guess maybe my question is, so the people in Georgia who don't have the court involved.
This isn't
You
foreclosure.
have
We're
it
not
over
even
there.
talking about foreclosure.
That's non-judicial over on the wall there. This is judicial.
Okay. My bad.
Can this process work, the same process here, work in a non-judicial state?
This isn't a foreclosure process,
There's the
guys.
process for non-judicial over there.
Okay.
This isn't a foreclosure. This is a court account.
Right.
That means there's a court case. If
In
there's no
Georgia,
court case,
you're going to
well, we are
have
not
civil
doing this.
cases, criminal cases, traffic tickets.
Now-
Those are all court cases.
Now, the details that are lined out on here, you can use in your other processes that are not court-based, except step 5. You're not going to be presenting any evidence to a judge.
This also can be used on your private side court case because you are the court. Court is the residence of a sovereign. Sovereign's wherever you're at. So if you're in a kind of an argument with some kind of big company or some private company, you're going to use some of these processes in here. There's just not going to be a court to send it to. That's all.
A court is a bank. And so this will work with any account that's a bank. Isn't a prison a bank? This could be used in order to settle an account to get a prisoner out of a bank because the body of the prisoner is currency. He's deposited in a bank. There is another loan out based on him as security for that loan. And basically the money order, the A for V, the 1040V, the notice to set off, all of this process could be going to settle his, quote, debt to society, unquote, and then the process would go back to the head banker, i.e. the head of the court, which would be the warden after this process was done. What would be the item that you're doing the A for V on? The minimus or whatever it is, that is the document held by the warden upon which he has deposited the currency and holds it in reserve for the lien.
With the original information being back to the original court case that this guy went in under, so that everybody again gets notification of what's happening.
Question for you. Like for instance, on a court case, say like most court cases, if I get a complaint or I have 30 days to respond. Now, and typically that's not the 30 days before I have to go to court. I just got to respond within 30 days. So, say for instance, I'm just thinking about this and I have only 20 days left. I have time to start step 1 and get to step 2. Is that the time to go and maybe ask for more time, or how do you do that? What do you do with that?
That's your choice. However, because of my personal experience with court cases, yeah, you may have 30 days to respond, but they're not getting a summary judgment or a default judgment in 30 days.
Right.
So I have responded on the private side, have I not?
Right.
So in reality, I'm still not going to file anything in the case because before they can get a summary judgment or a default judgment, I'll be done with my process and it'll be in chambers.
Right. I'm just saying, in case like they'll give you if I'm served. Say for instance, I was served last week.
I know.
Right.
Yeah, I gotcha.
And now, and before I do that, I at least got to go back to the court and do some type of response that I got.
He's telling
Really?
you don't have to go back
you
because
have to?
nothing bad's going to happen.
Where's my belief chart?
What he's telling you is, yes, the court says you got to respond to this summons within 30 days.
Right.
You don't respond to the summons at 30 days. After 30 days, the other side...
You did respond. You just didn't respond in the court. You're
Yes.
handling it on the private side.
Ah, okay.
They know that's going on. You can rest assured
Now,
that...
if you're worried that a summary judgment is going to go through,
Right.
start putting your evidence into the judge at step 2 or step 3 and let him know more to come in your presentment of evidence.
Okay.
I could send him, I could do step 1, then step 5, step 2, then step 5, step 3, then step 5, step 4, then step 5.
Okay.
Do you understand what I'm saying?
And again, if by chance didn't want to do all that, just followed along, and they did give a summary judgment, that's just another offer, correct?
Exactly.
And then once the summary judgment comes, then I take that summary judgment and then proceed forth with everything.
Because you're not going to get a summary judgment on day 30 when you're supposed to answer. They're going to put in a motion for it. They're going to wait 10, 20 days.
They have to get a hearing.
There's all these things that go on before anything ever comes down on you. Now, if you wait till the 29th day to start your summons, it's not going to be as nice as starting back at day 9 and getting into step 1. But even again, firing step 1 to the judge, he sees what you're doing. And nothing bad's going to happen to you before you get done if you then stay very timely.
Okay.
Gordon, you remember the case in which you were working with some, I believe, woman, and she put in a notice that she was going to do an administrative procedure and needed 90 days. And at the end of 30 days, the court responded. And what did the court do to her? Because she had done nothing.
You know, this is actually we were working. I was working a probate case up in San Francisco. And is this the one you're talking about, Jack, with our...
I think so, because some lady then started complaining that the court didn't give her time.
Well, I believe it's, correct me if I'm wrong, we had our friend in probate that showed up at PTK with all the wines. The long and the short, this gentleman was a sole heir to a $9 million estate. 3 weeks prior to the end of his mother's demise, she altered the will. The trustees then got her to alter the will, including leaving $100,000 to the dog, which one of the trustees was taking care of. And he was very upset. And the long and the short is he wanted to stop the court from, number one, selling the family home up in Tahoe on the lake, the vacation home. He needed to have a bond in the court for $130,000, which Brandon did for me. And the long and the short is we went up and we filed this case, filed our stuff into the court that morning. We were number 3 on the docket sheet. And at the end of the court hearing, we had a full room. The entire case goes, everybody gets in and out of there, and all of a sudden just me and the client are sitting there. And the judge says, well, I guess that's the end of the business for today. And I stand up and say, excuse me, was not the so-and-so trust matter to be heard today? Now, my client is pretty rattled because the attorneys, I got plenty of money from the estate, are always there. They're not here. What's going on? I said, just relax. Judge says, well, I guess that wraps up business. And I said, excuse me, Judge, blah, 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 blah. And she goes, oh, yes, that matter has been put off for 60 days. Legal department had some questions. Would you like me to bring up the record? I says, oh, no, Judge. Thank you so much for your professionalism, your courtesy, and most of all, your kindness. And she smiled very nicely and said, you're welcome. And now the clients, we're walking out, and the client's going, what the F just happened? I says, well, we got our abatement like we requested. Time to go ahead and go back on the trustees and get this will squared away. So the judge says, legal department's got a question, I'm going to put it off 60 days. Then she asked me, do you want to bring it up now? You want to bring the file up? You like to have an argument? Oh, no, Judge. And we leave. Now, he tried to get this gal dismissed because she was crazy and this and that, and she had to go get another judge ruling. So this judge didn't like my client the least bit, and so he couldn't even understand what the heck just happened. So we got 60 days. And the client gets the thing. He says, you know something, Gordon? I didn't really need you or your bond. It's obvious that legal department had a question anyway. So I says, you think so? He goes, yeah, we didn't really need you, and I don't really want to pay you again to do this other stuff. Don't I have a credit for this? I says, I go and get you a bond. I work, for days. I fly to San Francisco. We got 2 days up here, and you think I haven't earned the money, huh? He says, no, I don't think so. And his wife's there. And I says, well, what do you think? She goes, no, you did. She's a little more sensible than a self-serving, parsimonious individual.
Ooh.
Parsimonious.
Stingy beyond belief. And he says, I got 60 days. I said, hey, do it. I said, what do you want me for? You didn't need me anyway. You just do it. You know how to go set all this and get the trustees out of there and do what the judge wanted, etc. because you're going to settle the matter. He says, yeah, no problem. Now, he's got some important things to do. He's got to go, he's a PhD guy, and he's got to go do some work up at a university in Canada for a week, and he's got to move the sister-in-law for a week in Utah. And he's got things to do, and so he doesn't do anything on the process. At the end of 30 days, the opposing attorneys all of a sudden put in something about, well, there's something wrong with this process, the bond, etc. And he comes back and he goes, what's wrong with it? I thought you guys did right. I said, what do you care? I thought this thing was legal. Well, why are they doing this? Bottom line, I says, after talking to Jack, and Jack says, that's warning one. 30 days, you've done nothing. I said, you've done nothing in 30 days. You better get to it. Time's running out. 10 days later, actually, they came at us 2 weeks later and said a little something. We fixed it real easy. No more comment. At 30, that was a little prompting. At 30 days, the court comes back with an offer from the plaintiff saying, the bond's no good, this is no good, that's no good, these guys, we want to do this. He says, what's this about? Warning number one in screaming, flashing sirens. He says, I said, you better get on. He says, look, I got things to do, and besides, I'll just ask for another 60 days. Besides, the judge hasn't given us the 60 like she said anyway, so she's out of line. I said, nasty judge, isn't she? Right.
Argument.
Debtor. I said, that judge was so nice to you in light of your past conduct. You don't understand. It's not what they say, it's what they do. You were given 60 days, and she knows and warning you, you can't be doing an administrative process to remove these trustees, and you're running out of time to get this done that you requested. Well, I just asked for more. Besides, she didn't. I said, do your thing. At day 40, the court ordered revocation of the bond, sale of the home. He goes, what's going on? So what are you asking me for? Remember, you're just going to ask for another 60 days. Remember, you had 60 days. What are you whining about? I said, don't you get it? They warned you. And in 20 days left, you think he could possibly do an administrative process when at day 40, he hadn't even begun? Can he do a complete process or even get anywhere in 20 days? He had dishonored what he had requested. We told the court, we're requesting 60 days pending an administrative process by us to settle the matter. And he didn't do it. Therefore, that made him not only a liar, but a debtor extraordinaire. And, of course, he put in that other stuff. And to this day, he's just what SOL. He's just stuff out of luck. You know, some people are just, who needs $9 million? He sure didn't. These trustees were straight up lying thieves, changed it with mom dying, this and that, doctor's report, she's on medication. They got her to sign something, and he had witnesses to the contrary with his own deal. I said, no, I can make that stick. That ain't a problem. I can have those trustees out of there in less than 40 days. Well, why don't you do it and I'll pay you later? I says, nah, I don't think I'll do anything for you on a what if later. So it gets really interesting, but the point that Jack is making is that when you don't act in good faith, latches set in a big hurry. Inexcusable delay in enforcing a claim. The doctrine of estoppel. The barring of a person in a legal proceeding from making allegations or denials which are contrary to either a previous act or statement by that person or a previous adjudication. And that estoppel and those doctrines of latches apply equally to the IRS and to everybody else. Where McGarry here, you were talking about tacit acquiescence. Let me tell you something. Tacit acquiescence is every bit as powerful as any absolute express sworn under oath. When you have a notary that issues out a certificate of non-response, and they don't respond to not only to the process and certificate of non-response, it's like manna from heaven. This government will agree with you every time to give you your remedy. But you really have to come to a understanding how powerful. And if you wonder, like Jack gave you just a minute ago, how powerful tacit acquiescence is, private international law, which we like and teach and do, What do you think the IRS uses? They never took you into a courtroom as you understand it as a layman. They simply sent you a few letters, said it's going to result in a notice of levy. Here's a notice of levy. After 2, 3, 4 letters, you get this notice of levy, notice of intent to lien, notice of intent to levy, all of these different things. Did they ever take you to the court? Your tacit acquiescence was no different than being in what you term a court of law under sworn oath and having it the same thing of, I agree to let them do what they want to do. That's why we use this so effectively. And this is also a good example for you because it's hard to believe some of these things that are so alien to you. What do you mean? Somebody just ignores it? And it's fact? Yes. You mean if you deny, you admit? He who does deny admits. That's a maximum law. Yes. Under door 4, you're arguing. He who does deny admits. Those are things you just have to simply look up for yourself in maxims of law, in other things, in contract books, and it's everywhere that you come to realize the extreme power of tacit acquiescence, and it's a two-edged sword. So we had one other little story we wanted to tell you to back up what Jack was teaching you, because Jack and Brandon both are extraordinary at being able to decipher a judge's order. Because they merely understand one thing right out of the chute, what we have been telling you. Everything is an offer. And we're running out of time. We want to get you out of here.
You know, our hero Brandon is running around here like a chicken with his head cut off. I found out he's got to be back in California on Wednesday, driving. I don't know. I think somebody better run interference so the cops don't stop him or something or other. But we are getting close to the end. This was a great audience. You really were. Thank you. You want to share one last story?
This is one of the neatest stories that we just love this one. This is a gentleman, we'll call him Larry. And Larry and 2 others had gone to trial on a particular multi-felony matter, a federal indictment. And they all quickly lost. They were advised to do things differently, but it was difficult for them to believe any of this stuff. They've been diehard patriots, and they weren't going to change. So they went ahead and went to trial, and they got sentenced February 8th of this year. Now, one of those wonderful diehard guys went in at allocution at sentencing and certainly read the judge a little bit of his mind about constitutional rights and a few other things. And the judge understood clearly and gave him 75 months. And they took him off to jail to start his term right there. The other 2 guys, one simply said, forgive me, and the other one said, I ain't got nothing to say. And they said, you 2 get 60 months. And a little bit of time, 6, 8 weeks before we call you to report to prison. We talked about this story just the other day a little bit, but it's worth kind of reading into the record for others. Now, that was February 8th they were sentenced. So we have 2 guys staying out of prison getting a chance to get their personal affairs in order. And it comes up to March 25th on Thursday, and they both receive a call to report to prison. It is not uncommon for these courts to allow people to stay out pending a little bit of organizing their affairs for 6, 8 weeks before they have to report to prison. It's not some rarity. And in the interim, their public defenders, of course, immediately filed an appeal for them. And, of course, they're now out on bond pending appeal. So Thursday, March 25th, roughly 6 weeks later, our 2 heroes get calls. And I call one of them up and I say, hey, are you interested, so-and-so, in hearing and maybe not having to report Monday? He says, nah, if it's God's will that I go, I'm going to go. I said, do you think it's God's will that you're away from your 5 children, etc.? He said, look, it's God's will. I says, hey, who am I to disabuse you of your beliefs? Disabuse means to free from fallacy or, your false impressions. The other one who had called me and alerted me to it, he says, can you do anything? I says, why couldn't you wait till Monday at 1 o'clock? Because you got to report Monday at 2 o'clock. I was being kind of, so why couldn't you wait till Monday to ask me if we could help? But in reality, it was a wonderful blessing that he called me on Thursday. And I called Jack and says, what do you think, Jack? Should we have a little fun with this one?
Go for it.
And Big Jack says, let's do it. So, probation calls our hero, Larry, up and says, report Monday. Larry calls Gordon up and Jack up and says, fellas, can you help? Yeah, we think we can do some fun stuff. He's living with 80-year-old mom, taking care of mom, a sweetheart of a guy, and he cares about mom. And he's taking care of mom, so mom's dependent on him, so it's important that he doesn't go to prison. So on Monday morning, now, it took us Thursday afternoon and into Friday to get this organized and squared and get Larry dialed in, and we gave him paperwork, and he prepared it, and certificates of service. He was able to get it into the mail about 5 o'clock Friday night and fax it to the probation department on Friday night. Like they're going to get it, right?
What kind of process is it that he's going to do in order not to have to go to prison? He's got to do an A for V, R for V, use his asset account to set off the total criminal charges on the case. Because you're just going to prison to pay your debt to society.
You're going to pay it one of two ways. You're going to A for V it or go do the time. Jack was right on the money. So, with some good advice, he had previously obtained the judgment and commitment, or what Jack referred to as the mitimus, the instrument that's going to hold him. No longer the indictment, it was now the judgment from the February 8th hearing.
And the sentencing.
Which was the sentencing. So he happened to have that in possession just in case he was going to take some advice from us. So it was nice that he had a certified copy of it, but I could have done it without.
That was a court case, so theoretically he could be doing just exactly what Brandon just described to you.
And that's exactly what we're doing.
That process is going to take a little longer than the weekend. So part of his process, he's going to ask the court for what? To abate the time for reporting pending the outcome of his process.
So here's what he put in. Now, we know that he's got a public attorney. So unless you get rid of him, you don't have any hope. So we did a couple of documents. First document was a conditional acceptance of the attorney. Since he was a public defender, we can't fire him. We didn't hire him. So we have to conditionally accept him, which is the same thing as neutering him.
Ouch.
So we conditionally accepted him and sent him a notice on proof of claim that he accepts private asset compensation payment. 2, he doesn't argue any of the facts in the public. And 3, assist the undersigned by bringing a record of set-off, settlement, and closure of the judgment. Remember, he got judged. He's going. On proof of claim that you bring a record of set-off, settlement, and closure of the judgment to the court for private negotiation for set-off, settlement, and closure, and for an order, judgment, and decree releasing all liens, levies, and attachments on any collateral belonging to the defendant, Larry Smith. The second one that needed to go out, and of course we got the A for V on the judgment. That went in, took care of the attorney, and the big one, we did a notice conditional acceptance. Thank you for your offer to report to probation, because he had to report to probation who's going to take him into the jail, because he didn't have the money to fly to Texas. He's in Phoenix. Thank you for your offer to report to probation Monday at 2 o'clock, March 29, 2010. The undersigned conditionally accepts your offer to report to probation, including but not limited to any orders for the defendant to show up and or report for incarceration on proof of claim that the undersigned is not entitled to an abatement in order to resolve the matter by way of the undersigned's private administrative remedy. On you proving that I don't have a right to an abatement so I can settle this and not waste valuable public resources. And on proof of claim that the letter and this appointment of the attorney, the one we just read you, to represent the undersigned as the authorized representative for the secured party credit for the defendant in this matter, that the start of the administrative process attached here to Exhibit A, 5 pages, and currently in process does not show that pending the outcome of said administrative process, there's not a good likelihood that the matter will be set off, settled, and closed, making the purpose of reporting to probation for incarceration and thereby increasing the public liability moot. At this time, I'm requesting abatement in your request to report to probation. Remember, probation works directly for the court. Probation called him, so we sent this to probation. Pending the outcome of the administrative process with the court to settle and close this matter. You may reach me at the phone number above. Please advise me of your acceptance of my request for abatement of this matter pending the outcome, which should now be scheduled for 60 days of the draft of this letter. If I do not hear from you, it is agreed that the matter is abated pursuant to the terms and conditions of this letter. Whoa, that's pretty presumptive. We're just going to send that and assume that we got a deal? Well, over the weekend, now this was faxed, and of course we drop it in the mail Friday night, so nobody's going to get it till Monday at the earliest. So Monday morning, and a call comes in from the ex-public defender, who says at 8:30 in the morning, I can't do that. He says, okay, no problem, I appreciate it. Click, it's not, that's about all that was kind of real softer a little bit, and that was all that said. An hour later, the attorney calls, and he says, you're supposed to report at 2 o'clock today. I want to know whether you're going to report at 2 o'clock pursuant to the court order. Yes or no? Larry says, I conditionally accept on proof of claim that the blah, 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 blah. And he reads off a bunch of his stuff off this. He was ready for him. Much like Julio was ready for the Attorney General to make him an offer. Hang up. He doesn't show up at 2 o'clock. Nervous as a cat on a hot tin roof, needless to say. All day, all night. Next morning, gets another call from the ex-public defender who says, if you don't report, the judge is probably going to issue an arrest warrant for you. It's a scary thing to hear that. Although some of you think, and some of you already know the answer, probably going to issue an arrest warrant? I kind of like that. But even more important than probably issue an arrest warrant was the fact of what he didn't say, or what he did say. When he said probably going to issue an arrest warrant, I think you can be rest assured that if you were supposed to be somewhere in prison at 2 o'clock Monday and you weren't there an hour or two later, that there's probably an arrest warrant already issued for you. Okay? So Tuesday morning when he says an arrest warrant's probably going to issue for you, he just said there was no arrest warrant. Boy, wasn't that a beautiful thing.
Yeah, but
Again,
there shouldn't be an arrest warrant because his counteroffer removed the offer from the table.
What Jack told you earlier, what they don't say, what they do say, you've got to listen. This is so beautiful, this kind of stories. They give you hope that, man, it's truly offer and acceptance. It's truly conditional acceptance. What did the guy say? Well, he said the judge was probably. That isn't what Jack heard. And that isn't what I heard. I heard that there was no arrest warrants, what I thought he said. Man, that was an exciting thing. We were jazzed. And, of course, Tuesday night, he's even more nervous. The roof got lots hotter. He's running all over the roof. He wants to go visit brother. And take mom over there. I said, go. You got to deal with him. Don't worry. You don't got to stay home and fret. Go enjoy yourself. You're on a track. He gets over to brother, and brother wants to call up the marshal service and ask if there's an arrest warrant for bro. Oh, yeah, there is. Now, bro, Larry, he can see on the docket sheet there's no arrest warrant, but the judge issues out an order that evening. Because Larry says to me on an email, and he's not home yet, he gets home at 9:30 and calls me. Brother not only asks, is there an arrest warrant, but brother asks, what could happen to mom? Who, aiding and abetting a fugitive? She could be arrested, they said. Well, if she's aiding and abetting a fugitive, she could be, but she wasn't. He doesn't understand he's not a fugitive, but just because I told him all evening, and then Jack tells him all morning Wednesday, he's going to turn himself...
First of all, he's asking questions of the public, and the public is going to lie.
Asked.
What could happen to mom? Well, space aliens could come and get her.
All sorts of stuff. But Jack asks her, all that. So he's going to turn himself in, and Jack's trying in the Wednesday morning, because I can't get anywhere with him Tuesday night. But this is the order, and this is what's so cool. The court has recently received 2 facsimile communications from Larry Smith that have been added. Smith is not the last name. That have been added to the record in the case. Doc 257, Doc 259. Larry asserts these filings have some legal effect on his requirement to surrender to the United States Marshal and serve his sentence of incarceration in this matter. He is mistaken. These filings are nonsensical and have no legal effect whatsoever. Wow, that's
First will be last.
Last will be first. Not very ambiguous. Okay, paragraph 2. Also pending before the court is Larry's motion for release on bond pending appeal. Remember, he was out. They're leaving him out on bond pending appeal. They're going to let him take 6 to 8 weeks to report. Larry failed to surrender on March 29th as previously ordered by this court. The court finds this fact clearly supports a risk of flight. Accordingly, the court orders that 1, filings by Larry entitled Conditional Acceptance of Attorney and Abatement, Doc 257, and Notice of Abatement of Surrender, Doc 258, are to be stricken from the record. And then number 2, Larry's motion for release on bond pending appeal is denied. Boy, that doesn't sound good at all. And this is where Jack just got done teaching you, because he tells you in this thing now, when he was offered Tuesday morning to be arrested, they said, well, the judge could probably arrest you. What did Jack tell you? If you get smoke signals, you get a phone call, you get a tap out on the ground, and you feel the ground thumping, read the Morse code. They're sending you a message. So he got another call Tuesday morning. The judge will probably issue an arrest warrant. Did Larry leave that unattended? No. Per our phone call this morning, the undersigned conditionally accepts your offer of being arrested upon proof of claim that you present the undersigned with an original charging and or accusatory instrument for the undersigned's reading and inspection so that the undersigned may set off, settle, and close this matter. And upon proof of claim that by failing to grant the undersigned adequate time to resolve the matter by private administrative process, that the public actors, including the prosecutor and public defender, are not acting in bad faith and are not becoming liable for the obligations and debts of the defendant. And the undersigned conditionally accepts your offer to arrest the undersigned upon proof of claim that the undersigned's efforts to save the public resources by assisting this court in settling this matter can be verted into a crime, and a few others. Just clean, sweet, straightforward. Tuesday night goes by. I can't convince him. Wednesday morning, Jack can't convince him, and he says, look, I've got a birth certificate. I got the defendant. I've got it A for B. I'm going to go down and stand outside the door and call them up and see if they want to come and get the defendant. He says, what do you think's going to happen to me? I says, I'll see you in 60 months. He says, you really believe so? I said, I believe that, but let me call Jack. Jack, what do you think's going to happen? He says, I'll see him in 60 months. Something to that effect, something kind of that way. And the long and the short is, Larry did not take care of what the judge told him to take care of. The judge said, you have an appeal outstanding. The last will be first. This is what Jack tells you. The last is first, the first is last. The first thing then is, you've got an appeal outstanding, and you're out on bond. And the second, or the first thing, which is now last, we're going to strike these things from your deal if you don't get rid of those. That's what the judge was saying. Get rid of the...
Who appeals the case, the creditor or the debtor? Debtor. So the judge said, I am looking at the record here, and all I see is a debtor because there's an appeal.
So I tell Larry...
Therefore, I'm striking your filings. Therefore, you better get your ass in here and serve your time. Therefore, everything he did as a finding was based on Larry being a debtor. Because of what? 2 things. Public bond, which the court has the authority to revoke at any time. So what does Larry do with the public bond?
He did
Accept
nothing.
it for value, return it, replace it with a private bond. What does he do with the appeal? Oh, my bad.
He rescinds it.
Non-pro-tunc, rescind it for a mistake.
That's all he had to do.
Resubmit the administrative procedures.
That's all Larry had to do.
All
he was
had to
counseled by Jack. Do 2 things. A for B, the bond, and undo that appeal request. because you signed it. And he goes, I didn't sign that. Jack goes, you have an attorney, right, at that time? He goes, yeah. Did the attorney put it in? Yeah. Did the attorney sign it? Yeah. Is the attorney your power of attorney? Yeah. Then you signed it. Yeah. Oh, okay. So he knew he had those out. These are facts that are simple. Tuesday morning, he went in, and we'll see him in 60 months. Now, he did protect Mom, so now nobody's home to take care of Mom, so we know he's really concerned about Mom. It's not that he isn't concerned about Mom. He lacked the faith. But he couldn't even see it right out in front of him. We don't know why some of our students do this. Some of you say, well, I hear some of your students on Monday night, Gordon, they failed, they went to jail. And we tell you, yes, they get right up to success. And this is what Jack and Brandon were talking about earlier. Don't you feel worthy of? You have been programmed all your life, and you've got to unprogram. And it's really, you'd think, no, I'm not programmed to fail. Au contraire, great ones. We are all imprinted. We all are subject to subliminal input over our lives. I encourage you, we're going to wrap this up so we don't need to belabor it, but
just real shortly, I don't think we told the story about the guy who is so close right now to sealing the deal and having his administrative process get him out of a criminal case. The court is so desperate to have a nexus that the court a week or so ago appointed him a public attorney.
Hold up, Jack, because this is beautiful. Let me give you just a small set stage. We've been doing the administrative process with this guy over this amount of time. This all started a while ago. We terminated his attorney way back when, and here we fast forward into the month of May, and about a week ago, like Jack said. So, Jack, go ahead.
He started his administrative process back in January, and he put in his A for V, R for V in January, going to his asset account. The judge in this case just appointed him a public attorney, nunc pro tunc.
That's now for then. I mean, that's a way to backdate documents. Craziest thing you ever saw.
December 2009.
Now, this guy did his A for V January 8th, and the judge...
Why did the judge just appoint him attorney back to December? So that he would have a public benefit of a public attorney in December, so a month later in January, he could not possibly have an asset account accessible to the court because he had an attorney appointed as a benefit a month earlier. I started laughing my ass off, and
what are we going to do?
What are we going to do? Yeah, he's laughing too. Oh, that's easy. We're going to accept that for value. Nunc pro tunc back to 2 days after they nunc pro tunced it back in December, so he still was out without a public benefit in January. So we're going to see what they're going to do now. You understand, when you keep up with the paperwork, when you know what these clowns are doing, they get absolutely desperate to try to put anything in the record that you don't deal with, so it's presumed to be voluntary consent under some operational law to screw up your remedy. You tell me these remedies aren't valid, why are they becoming so crazy to try to make sure in some principle of law that they're not there then?
And that appointment of attorney has a date of April 23rd, and next to it is nunc pro tunc December 9th or something. So we just did ours like April 25th and nunc pro tunc December 11th. You know?
God, I just love Disneyland. It is so incredible.
It's truly a marvel. Learn your stuff. Don't be dejected. And when you hear people that fail in these things, wait a minute. Why don't you ask why they failed? And I can't tell you why some of our wonderful people just won't do what we ask them to do. Larry, the guy that's supposed to report to prison. I said, Larry, you think they couldn't have come and arrested you? They haven't done it. They don't even call you except the attorney. They call you all the time. Why didn't... I said, your offer was to the probation, the court. Did the court contact you or an ex-attorney? But he can't see. He has eyes that can't see and ears. He just rather go do 60 months and nothing. So the long and the short... hang on just one sec, Rourke. This is truly the most wonderful game you're ever going to play, because it is in fact truly a game. They are not malicious about this stuff. They are truly not. These judges really love seeing you people come in and brightening their day. Debtor after debtor comes in. Why do you think they sleep on the bench, do all that kind of stuff, don't have to pay attention? It's so tedious to deal with people fight and argue and stupid attorneys all day long. These judges are bored out of their gourds. They're bright people. You think they don't love seeing you come in and doing some fun stuff? We've got so many cool comments from good judges that I'm going to tell you, just like the AW at the prison, you've definitely made our lives interesting here. We hope that Brandon, Jack, and I have made your lives interesting. We want to thank Brandon's brother Garrett, Deborah Velez, Celestina, Brandon's girlfriend, for all their assistance and help. We love and appreciate you all dearly. We really, really do. And if we offend any of you, forgive us, because we are just crazy. And we have one question from Rourke real quick, and then we'll go.
First, we got to put in our legal thing. Remember, nothing that we've told you all weekend is the truth. It's here for entertainment purposes only. Excellent. We have achieved our goal. Question? There was.
It seems as though this knowledge, it seems like all of us at a given point in the future could easily go help a lot of people.
It seems like all of us or all of you could help other people at some given point in the future. What do you think we're telling you? There are so many problems out there that I offer my services. Jack and I work helping a lot of people and things. We charge for it. You can call me because we do services. We do mentorship programs, immersion programs, work cases, help you get through things. Once you get proficient at this, it's a beautiful living. The problems on 300 million cattle is not going to be foreseeably fixed in the next decade or two. And you could multiply and multiply and multiply, and you're going to find that not a lot of people will take advantage of this because they just can't believe for their life. For their very life, they'd rather go to jail. You heard about the Florida guy. Well, I'll just try it next time. I'll just go do 11 years right now. Because he doesn't want. You know, there's no rhyme and reason to people's silliness any more than you see a lot of people do a lot of things contrary. People are good. God is good. We got it made. See y'all at the top.